6, 5, 4, 3, 2.
Hello, everyone. Thank you so much for being with me here today. My name is Dan Tokaji, and I am a law professor at The Ohio State University, Moritz College of Law. I feel very fortunate and privileged to be with you here today at the Electoral Court. This is an institution for which I have a very high personal regard, in no small part because this institution is highly regarded in the United States and around the world for being a trustworthy adjudicator of electoral disputes. I know that you have many here in Mexico, and of course we have our share in the United States as well. What I am looking forward to speaking with you about today is the right to vote in an age of discontent. I'm going to be focusing on the American experience, and especially what has been going on in the United States over the last 10 years or so. When I say an age of discontent, what I mean to express is that these are very challenging times for democracy. Certainly for us in the United States, since the 2016 election and during the presidency of the United States. At the present moment, President Trump is facing the very real prospect of impeachment proceedings being undertaken in the next few weeks and months, something that I will talk about in my presentation. But I don't want to make this discussion just about President Trump, because I believe that the problems, the challenges, the conflict that we are experiencing in the United States over our current president is really just the tip of the iceberg. It is reflective of some bigger problems in our system of government, including voting rights, that I am hoping to provide some background to you on today. I also think and hope that some of the things that I have to say to you today will be relevant to what's going on in this country and in other countries as well. Because it is not just the United States and Mexico that are experiencing challenges in our democracy right now. It's around the world. We are seeing fragmentation. We are seeing the rise of extremist, sometimes authoritarian movements. And what I'm hoping to discuss with you, and what I'm hoping that you all might help me think through, is whether there are lessons that might be drawn from our respective experiences that can help us improve democracy in our countries and around the world together. I've put on the screen here a tweet from Donald Trump during our last presidential campaign back in 2016. It so happens that at the time, 2016, that was the last time I had the privilege of coming here to Mexico and speaking to you all at the Electoral Court. And I do remember saying to some of you around that time, when I was asked whether President Trump could win, well, my response was, I don't think he's going to win, but he could. I thought he could in part because even though his public approval ratings were very low and have remained so, around the low 40s, his opponent, Hillary Clinton, also had very low public approval ratings. And if you were following the 2016 election campaign closely, you might have noticed something like the tweet that I've put up here. Hillary Clinton should have been prosecuted and should be in jail. Instead, she is running for president in what looks like a rigged election. There are a couple of things in this tweet which was not unusual for Trump to be sending during this election that are very unusual for us in the United States. The first is for one presidential candidate to be saying that his or her opponent should be imprisoned. This is not something that is typical in the American experience, although it has happened in other democracies, but we like to think of ourselves as an entrenched and strong democracies, and these aren't the kinds of statements that we expect of presidential candidates in a strong, healthy democratic system. The other thing that is remarkable about this tweet is the statement that this was a rigged election. Now, you may have noticed he stopped saying that after he won the election, but for a major presidential candidate to say in advance that the election is rigged is also something that, again, we've seen in other countries before, but is unprecedented, I would say unique in the American experience, really encouraging a lack of trust in our democratic system. What I'd like to do with you in the remaining time we have today is to explore some of the reasons for this. And to do that, we have to go back in history and then go forward into the future as well. As I mentioned a few moments ago, we are right now experiencing the possibility of impeachment proceedings growing out of conversations and other communications between the Trump administration and the president himself and President Zelensky of Ukraine. I'll have more to say about this later, but what we're seeing from our president right now is his apparently preparing for his next run for president, which will be next year, by doing something that, again, is unprecedented, enlisting the assistance of a foreign government, it seems, in investigating one of his political opponents. This is former U.S. Vice President Joe Biden, shown with his son Hunter Biden, who is involved in these allegations. Another tweet from President Trump in recent days has doubled down on what he asked President Zelensky to do by suggesting that not only the Ukraine, but also China should be investigating the Bidens. The matter is now in the hands of the United States Congress. And as I'll discuss later, the House, the lower chamber of our Congress, is controlled by Democrats. Speaker Nancy Pelosi leads the Democrats in the House, the Senate by Republicans. So I'll share some thoughts on impeachment and what it means as well. The basic plan for my presentation is to start with some history of the United States and the right to vote in the United States, a history that is deeply entwined with both race and gender equality, talk about the right to vote today, and some of the current and recent decisions of our courts, especially the United States Supreme Court in the area of voting rights. And finally, talk about the future of the right to vote, including the near future and the current proceedings over impeachment and what they say about American democracy, as well as the long-term challenges that I believe our system is facing. Well, let me start with this statement, something that our Supreme Court has long stated, but not always adhered to. Our Supreme Court has long held that the right to vote is fundamental because it is preservative of all rights. It first said that in 1886 in a case called Yickwo versus Hopkins, and has repeated this statement many times since then. The irony is that at the very time the Supreme Court wrote these words, saying that the right to vote is fundamental, African Americans in the United States were being disenfranchised, were being prevented from voting en masse throughout the South, throughout the states of the former Confederacy. Let me go back even further into our history to start with. At the time that our country, the United States of America, was founded in 1776, the general rule was that only white men were allowed to vote. And in fact, not even all white men who owned property. After our Revolutionary War, white men who did not own property were given the right to vote. But women were still denied the right to vote. And African Americans were denied the right to vote until after our Civil War over the issue of slavery, which ended in 1865. After the Civil War, the United States, during the period that is known as Reconstruction, adopted a series of amendments to our Constitution. The 13th Amendment to our Constitution, which abolished slavery. The 14th Amendment, which among other things guaranteed equal protection of laws to newly freed African Americans, but also to everyone else. And finally, the 15th Amendment, which expressly prohibited race discrimination in the right to vote. The 15th Amendment became part of the United States Constitution in 1870, 5 years after our Civil War ended. One of the remarkable and very sad things about our history is that the words on the page, these rights enshrined into our Constitution, have not always been respected and have not always been enforced, including by our Supreme Court. And so it was with the right to vote, which the Supreme Court declared fundamental in Yikwo versus Hopkins back in 1886, and with the 15th Amendment, which again expressly prohibited race discrimination in voting. Between the 1870s and 1900, southern states in the United States, states that had rebelled against the United States government during the Civil War and attempted to secede, adopted a series of amendments to their own state constitutions and other laws that were expressly designed to keep black people from voting. And one of the things that is remarkable, if you go back through United States history, is just how explicit and blatant they were about their intentions, despite the fact that the 15th Amendment, which prohibited race discrimination in voting, had been law for several years. The governor of North Carolina, for example, in 1900, when he led the charge to adopt state constitutional amendments that would effectively keep blacks from voting for most of the rest of the 20th century, said the words that you have on the screen here. I am proud of my state, moreover, because there we have solved the Negro problem. We have taken him out of politics and thereby secured good government under any party and laid foundations for the future development of both races. Governor Aycock was very explicit that his goal and the goal of those who were part of his movement was to keep African Americans from voting, despite the fact that this was illegal under our Constitution. One of the big lessons, and it's a lesson not only for us in the United States, but I think for people everywhere, is that articulating a right, putting it down in your laws is one thing, but the realization of that right, quite another. Just because the words on the page say you have a right, such as the right to vote, doesn't make it a reality. And so it remained in the United States for most of the 20th century. Throughout the first half of the 20th century. From the 1900s all the way until the 1960s, most African Americans were kept from voting. Southern election officials and state leaders used a variety of means to prevent people from voting, and one of them was just to prohibit them, often with threat of force, from registering to vote at all. I've shown on the screen here a picture, a famous picture of a registrar in the state of Alabama, one of the southern states, the former slave states that had kept blacks from voting since the late 1800s, pointing his finger at Dr. Martin Luther King, the American civil rights hero, as he was trying to help African Americans in Alabama register and thereby exercise their fundamental right to vote. A few months after that, President Lyndon Johnson signed what is perhaps the most successful piece of civil rights legislation of all time, the Voting Rights Act of 1965, which successfully broke down the barriers that had prevented African Americans from voting for nearly a century since Reconstruction. This law prohibited race discrimination, was later expanded to prohibit practices that result in race discrimination. It also suspended literacy tests, tests requiring people to be able to read, or sometimes to translate or interpret provisions of the Constitution or other laws in order to exercise their right to vote. These laws were often administered in a discriminatory way to keep blacks from voting. Finally, it required covered states, which at the time were states in the South, states with the worst history of race discrimination in voting, to get advanced permission from the federal government, either from the United States Department of Justice or from a federal district court, before they could change their voting rules. This was designed to prevent states from doing what they had frequently done in the preceding decades, which was every time one practice designed to keep blacks from voting was stopped, a new one would pop up in its place, sort of like a many-headed hydra. So I've put up here the key milestones in the right to vote. Women didn't win the right to vote in the United States until 1920, and in the coming year, we will be celebrating the 100th anniversary of women's gaining a constitutional right to vote in the United States. The difference was that after women won that right with the adoption and ratification of the 19th Amendment in 1920, that right actually stuck, whereas with African Americans, it did not, even after the enactment of the 15th Amendment in 1870. One of the lessons to be drawn from the United States history when it comes to voting rights is not just that it's one thing to put a right on paper, another thing to make it a reality, but also that it has primarily been through the political process itself that the greatest gains in voting rights have been achieved. The 15th Amendment, later on the 19th Amendment that gave women the right to vote, the 24th Amendment, which abolished the poll tax in federal elections, and the 26th Amendment that gave people over 18 years old in the United States the right to vote. The Supreme Court, however, has, over the last half century or so, played an important role in protecting our voting rights. And in the second half of my presentation, talking about present-day issues, I'm going to talk some more about some of the current issues. Before getting to that, however, I want to talk about a really important historical case. This was a case involving the poll tax. Back in the 1960s, around the time that the Voting Rights Act was enacted, a number of states had laws requiring that you pay a poll tax in order to be able to vote. Virginia, one of the southern states that had formerly been a slave state, was among the states that had this poll tax. And their poll tax was $1.50, which may not sound like much. Today it's not a whole lot. Even back then it wasn't a huge amount of money. But this law had a particularly negative effect on poor people and African Americans in the South who were disproportionately poor. Poll taxes were often used as a means by which to keep blacks from voting in states like Virginia. In this very important case, Harper versus Virginia, written by Justice William O. Douglas, the Supreme Court struck down Virginia's $1.50 poll tax under the Equal Protection Clause of the 14th Amendment to our Constitution. This is one of those cases that actually makes good on the court's promise that the right to vote is a fundamental political right. Justice Douglas, in that case, said that one's right to vote and one's ability to participate in electoral politics shouldn't depend on whether you're rich or poor. Something that strikes, I think, most people in the United States as true today. But as we'll see, it is a promise or a guarantee that has not always been honored, and in my judgment, to this day is not fully honored. Well, this helps bring me to the second part of my presentation. We've talked so far about the past, the history of voting rights in the United States. What I want to talk about now are contemporary issues in the United States, including some recent decisions of the United States Supreme Court. And I'm going to break down this portion of my discussion into three subparts. First, I want to talk about issues of vote denial, as it is sometimes referred to in the United States. That is, barriers to people actually being able to cast their vote and have their vote counted. We have seen over the past 15 years or so increasing litigation over these issues, as I'll describe in a moment. But being able to cast a vote that gets counted is only one dimension of the right to vote. In order for the right to be meaningful, one must also have equal representation. Over the last few years, and especially over the last 2 or 3 years in the United States, we've seen a great deal of important litigation over the way that district lines are drawn. And I'm going to be talking about that in a few moments. Finally, the right to vote should also be understood to include a right to have influence on our decision makers. Even if you're able to vote, and even if you're able to elect representatives who, in some respects, share your views, the right to vote doesn't mean very much if there are other things, like the influence of money in politics, that effectively deny you equal influence on par with wealthier citizens. And so I want to talk about all three of these aspects of the right to vote in the time that we have here. But let me start with participation and issues relating to what we in the United States in the election law community usually refer to as vote denial. We've seen over the past 15 years or so an increase in practices that have the effect of, and sometimes are designed to make it more difficult for some groups of people to vote. Laws that sometimes appear to be adopted with a partisan intent. I've referred to this in my scholarly work as the new vote denial, the old vote denial being literacy tests, poll taxes, and other practices that were used to keep blacks from voting from the late 1800s through the 1960s. Just to give you a sense of things. I know that you all here in Mexico have a lot of election law cases which come before this tribunal. We don't have quite as many, but I've put a bar graph on the screen that shows that the number of cases has jumped up precipitously, or jumped up significantly, since around 2000, when we had the disputed election between George W. Bush and then Vice President Al Gore, and the current period of time. 2004 was the height of litigation over these voting issues. And this rise in litigation, as I mentioned, can be traced to the Bush against Gore election and the Supreme Court's opinion by the same name, which effectively resolved the election in George W. Bush's favor. In the course of doing so, however, the court said this: having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over that of another. And we've seen a lot of cases in the years since Bush versus Gore that have either explicitly or implicitly relied on this basic principle. I'm just going to talk here about the area that's probably been the most contested in the United States: voter ID laws. Now, in a place like Mexico and lots of other countries, you might be wondering why this is such a big deal. Because everyone, or at least most people, have identification, photo identification. That's not the case in the United States. Well, most people have it, but there are a significant number of people, disproportionately poor people and people of color, who do not. The principal form of identification that people have in the United States is a driver's license, like this one here. But if you're poor and can't afford a car, well, you're not likely to have a driver's license. So it's been estimated that roughly 10%, 11% of the United States voting eligible population does not have photo ID. And the people who lack photo ID are disproportionately poor people and people of color, African Americans and Latinos in particular. Nevertheless, in this case, Crawford versus Marion County, the United States Supreme Court upheld one state's photo ID law, the state of Indiana, against a facial challenge. What the court did in that case was essentially to balance the burdens that the law imposed on some people against the benefits of voter ID laws, including prevention of fraud and increasing voter confidence. And on that ground, the Supreme Court upheld Indiana's photo ID law. We have seen a lot of other cases in the United States on voter ID and related issues, including issues related to our voter registration process, which over 50 years after that picture that I showed you earlier of Registrar Golson pointing his finger at Dr. Martin Luther King, remains a big subject of controversy in the United States. One of the things that's distinctive about our system is that it's highly decentralized. So each of our 50 states has its own election laws and its own practices, sometimes varying not just at the state level, but even at the local level. So we've seen a number of challenges brought to laws alleged to unfairly burden voting in the United States. I've just mentioned 4 of them in the slide that you see on the screen right now. One case in North Carolina was actually successful with one of our courts of appeals, the Fourth Circuit Court of Appeals, concluding that a law that the North Carolina legislature adopted was intended to discriminate against African Americans. It is very uncommon in this day and age for a court to conclude that a law intentionally discriminates against a certain racial or ethnic group, in part because nowadays, even if that is the intention, people seldom admit it. But the court found the pattern of discrimination against African Americans so stark that it found intentional race discrimination in violation of both the Constitution and the Voting Rights Act. The court noted that North Carolina's law targeted African Americans with almost surgical precision. In another case, however, arising out of Wisconsin, a state that is in the north, in the Midwest, not too far from Ohio where I live, the court upheld a voter identification law, finding that plaintiffs had failed to show either intentional race discrimination or an impermissible racial effect. However, the Court of Appeals in that case also upheld a court order that made it easier for people to obtain the required ID. Texas is a state with a long history of race discrimination in voting, discrimination against both African Americans and Latinos. In the VC versus Abbott case, the Fifth Circuit Court of Appeals initially struck down a very strict voter ID law that Texas enacted. A district court found that it both had the intent and the effect of discriminating against Latino voters in Texas. However, the legislature subsequently adopted a modified version of this law, making it easier to vote even if you did not have the required ID, which the Fifth Circuit Court of Appeals wound up upholding. The last case out of Ohio was one that I worked on personally, I must disclose. This was a case that challenged Ohio's practice of purging people from the rolls, that is, removing them from the rolls if they had not voted over a certain period of time. We challenged this practice in Ohio on the grounds that it violated another federal voting law, the National Voter Registration Act, which had been signed by President Clinton in 1993. The Court of Appeals for the Sixth Circuit agreed with us that this law violated that federal voting rights law. However, the Supreme Court, in a 5-4 decision, disagreed and upheld Ohio's practice of initiating purges or the removal of voters from the rolls based upon their failure to vote. Well, that's participation. The next aspect of the right to vote that I want to talk about is representation. And here the term that is most often used among election law experts is vote dilution. When a group's representation is denied, even when that group is able to cast a vote and have that vote counted, we refer to that as vote dilution. And there are two types of vote dilution in particular that I'd like to speak with you all about today. One is racial gerrymandering, and the other is partisan gerrymandering. Both of these have to do with redistricting. In the United States, we elect almost all of our representatives and all of our members of Congress through single-member districts. At the beginning of each decade, after the United States Census, which takes place in years ending in 0, every state has to redraw all of its state legislative and congressional districts in accordance with the latest U.S. Census figures. Usually, it is the state legislature that is responsible for drawing district lines. In many states, the state legislature draws its own districts. Well, as you might imagine, this creates a conflict of interest. So here's the most important point. Sitting legislators, they're not exactly neutral. They have an incentive to draw district lines that benefits themselves and their own party while weakening other groups, including the other major political party and sometimes racial or ethnic minority groups. Let me talk a little bit about minority vote dilution first and then turn to what we call partisan gerrymandering. The first case I want to talk about is a case that invalidated a core part of our Voting Rights Act. As I mentioned earlier, the Voting Rights Act required certain states, primarily states that were in the South, to get advance permission before changing their voting rules. In Shelby County versus Holder, the Supreme Court, again by a 5-4 majority, you may see a theme developing here, struck down this provision of the Voting Rights Act on the ground that the coverage formula no longer reflected current conditions in the United States. It basically treated states unequally without a good reason. The result is that Southern states no longer need to get advanced permission from the federal government before they can change their voting rules. The North Carolina law I mentioned earlier was one of the laws that was adopted immediately after the Shelby County decision. But Shelby County probably had its biggest impact on minority vote dilution, in particular because states no longer had to get advance permission to put new redistricting plans into place. Alabama, I've already alluded to this, is one of those states with a particularly ugly history of race discrimination in voting. And Alabama drew districts after the 2010 census that, in the view of some people, were designed to minimize the voting strength of African Americans. Alabama is a majority white state in which a significant supermajority of whites vote Republican. It has a substantial black minority, almost the vast majority of whom vote Democratic. What Alabama did when it drew its districts was to concentrate blacks into a relatively small number of state legislative districts. And in this case, Alabama Legislative Black Caucus, the Supreme Court said that the plaintiffs could make a claim that this violated the Constitution. This is what we call a racial gerrymandering claim. The argument is that race was the predominant factor in drawing district lines, and there wasn't a good reason, such as compliance with the Voting Rights Act, for doing this. Another case, Bethune-Hill, also allowed this type of claim to proceed in Virginia, and ultimately the plaintiffs succeeded in having a number of the districts in the state of Virginia declared unconstitutional racial gerrymanders. The final case, a case out of North Carolina, another southern state, was a case in which the United States Supreme Court struck down 2 of North Carolina's congressional districts, holding that race was the predominant factor in drawing these lines and that there was not sufficient justification for doing so. Here are the districts in the Cooper versus Harris case. As you can see, even from a quick glance, even if you're sitting on the other side of the room, these are very oddly shaped districts, which the court concluded were drawn with the predominant intent of concentrating African Americans without a good reason for so doing. My state, Ohio, that's the state that you see on the screen right now. We're also a state in which the majority party has used its power over redistricting to advance its own interests. In Ohio, well, we have roughly an equal number of Republican and Democratic-leaning voters. President Obama, a Democrat, won Ohio twice in 2008 and 2012. President Trump won Ohio in 2016. And yet, as you see from the screen there, Ohio's 16 districts are not exactly evenly divided. 12 of those districts are Republican districts and have been so since they were drawn in 2011. The other 4 are Democratic districts and have been so since they were drawn in 2011. Now you might be asking yourself, How do you do this? If a state is roughly evenly split between Democrats and Republicans, how in the world do you draw a plan that's so imbalanced towards one party? It just so happens the party that drew those lines. The way that you do it is you pack as many of the other party's voters in as few districts as possible. And that's exactly what this plan does. The Democratic districts, the 4 Democratic districts, are all between around 65% and 80% Democratic. The Republican districts are all between about 54% and 64% Republican. So Republicans have a safe margin in those districts without wasting too many votes. This is one of those districts, a particularly packed district. It goes from Akron to Cleveland. So this is what I call the LeBron James district, right? He's from Akron, but used to play in Cleveland. At some points, it's just a little bit wider than the highway itself, but drawn in a way that is designed to pack Democrats, many of whom are African Americans in that district. Now, we've seen a number of cases brought in recent years challenging partisan gerrymandering. The basic argument is that plans like Ohio's are unfair, that they discriminate against the non-dominant party. Sometimes it's Democrats, sometimes it's Republicans. In Wisconsin, Democrats made a claim that the Republican legislature had drawn state legislative plans that were partisan gerrymanders. The district court, the lower trial court, agreed with this claim, but the Supreme Court sent the case back on the issue of standing, whether the plaintiffs were entitled to sue. District courts also issued favorable rulings in partisan gerrymandering claims in 2 other cases, one out of Maryland, in which it was actually Republicans challenging a plan that had been drawn by Democrats, and the other in North Carolina, in which Democrats challenged a Republican-drawn redistricting plan. Well, as I say, in all 3 of these cases, as well as in cases out of Ohio and Michigan, district courts ruled in favor of plaintiffs, the people challenging partisan gerrymandering, but the Supreme Court saw things differently. Again, on a 5-4 vote. In Rucho versus Common Cause, decided earlier this year, the Supreme Court declared that partisan gerrymandering is a non-justiciable political question. That is to say, it is not a question that courts have the power to decide. That is a question reserved for the political branches of government, and in particular, for the legislature. The result is that these kinds of claims can no longer be brought in any federal court. However, there have been partisan gerrymandering claims, and still are, brought in state court. And in fact, after this decision came down, a state court in North Carolina declared that this plan violated the state constitution. So there is at least a ray of hope with respect to partisan gerrymandering, but nowadays it lies at the state level, not the federal level. Congress could, in theory, the United States Congress, adopt legislation to fix the problem of partisan gerrymandering. As a practical matter, they're not likely to do so anytime soon. Let me talk finally about influence and what I call vote disassociation. What I mean by this is dissociating or separating the right to vote from any real political power. And the big culprit in the American system, in my view, is the influence of money in politics. As you may be aware, we have a huge amount of money that is spent to influence elections. In 2016, we had $3.1 billion raised by federal candidates and $1.8 billion raised by super PACs. I'll say more about super PACs in a few minutes, but basically they're outside groups, which in theory aren't connected to the political parties, that only make expenditures in political campaigns, but don't contribute to candidates' campaigns. It's not just the money, however, that is the problem. That is the amount of money, but where that money is coming from, where the real serious issues lie. And so here I want to talk a little bit about the First Amendment. The United States First Amendment protects, among other things, the freedom of speech. It has, since the 1970s, been held to prohibit restrictions, at least some restrictions, on campaign spending. In the Citizens United versus FEC case, which was decided almost 10 years ago, the court held that corporations have an unlimited right to make independent expenditures in federal elections, striking down a provision of federal law that had long prohibited corporations from making expenditures to influence federal elections. The result of the Citizens United decision was not just that corporations could spend money to influence elections, but it has led to the rise of these super PACs and outside groups that effectively have an unlimited ability to spend money to influence elections, financed not just out of corporate treasuries, but also out of the bank accounts of wealthy individuals. So we've seen a flood of outside money in recent elections. My co-author Renata Strauss and I wrote a report a few years ago documenting some of the effects of this money. And what we basically found, to make it simple, is that we have more and more money going outside the system, going outside of parties and candidates, because you have contributions limited to both parties and candidates. Instead, what's happening, because there are no limits on the amount that can be given to or spent by these outside groups, you've got more and more money going through these outside groups, which limits accountability, because these groups aren't accountable to the public. We don't vote on them in the way that we vote on parties and candidates. So here's a political cartoon that makes fun of this situation. This freedom of speech that we all enjoy is a great equalizer. Well, the reality is the corporations, as well as wealthy individuals, have a great deal of influence, not just on elections, but on the policy making that happens after elections are over. It's also one of the things that may be contributing to the intense polarization that we see in the United States. When we wrote our report, A New Soft Money, one of the people we interviewed was this former member of the House of Representatives who said, no one's saying, here's 50 million for a good compromise. All right, I want to close with just a few remarks on what the future might hold. As I've already mentioned, political polarization in the United States is very intense right now. And with this, we're seeing a decline in faith or belief in democracy, especially among younger voters, millennials. I've put some of the statistics up here on the screen, but the basic concern is that people increasingly, especially younger people, have doubts not just about whether our voting rules are fair, but about the future of democracy and whether it's a good system of government. I think this is something, for those of us who are elections and voting experts, we should be really concerned about this. It's not just the United States, but in some ways, maybe this is my own vanity as an American election law professor, I think it's especially worrisome given the historic role that the United States has long played as a leader among democracies around the world. Polarization has reached a really critical point in the United States, where both the parties, their leaders, and indeed ordinary citizens are very much divided along party lines. Something that is exemplified in the current fight over impeachment that I mentioned at the outset. I'm going to bypass some of the details of impeachment, only say it's the House that has the power to impeach the president. It can do so by a majority vote. The House is now controlled by Democrats, so there is a very high probability that Democrats will in fact vote to impeach the president. But there's a second step if the president is to be removed from office over the Ukraine affair or anything else, and that is for there to be a trial in the Senate. It is the United States Senate and its 100 members, 2 from each state, that has the power to try and ultimately the decision whether or not to convict the president, and only if the president is convicted can he be removed. Well, Democrats control the House, but Republicans control the Senate, and moreover, it takes a 2/3 vote in the Senate to remove the president from office. What that means is that it's going to be very difficult to not impeach, but convict President Trump of anything. The standard under our Constitution is treason, bribery, or other high crimes and misdemeanors. Well, we'll see what the House and perhaps ultimately the Senate have to say about this. But there is at least an argument, which Democrats are currently making, that the president solicited a bribe from President Zelensky. And we have at least some support in the partial transcript that has been released of a telephone call from President Trump to Zelensky right after Zelensky's victory. During this call, President Zelensky mentioned that he would like these anti-tank missiles called Javelins, in response to which President Trump asked for a favor to investigate something called CrowdStrike, which is a conspiracy theory having to do with Ukrainian interference in the 2016 election that has pretty much been debunked. He then asked about President Zelensky investigating Joe Biden's son, who was on the board of a Ukrainian company at the time that Joe Biden was the Obama administration's point man on Ukraine. There's at least the suggestion in this transcript, which is supported by further evidence in a whistleblower complaint, that the president was suggesting a quid pro quo, right? That I'll give you aid or arms if you investigate my political adversary, which very well could be considered bribery. We haven't had many impeachments in United States history. President Andrew Johnson back in 1868 was impeached but escaped conviction by 1 vote. President Nixon resigned under a cloud facing the possibility of impeachment in 1974 during the Watergate scandal. President Clinton was impeached for perjury in connection with his sexual relation with a White House intern, but ultimately he quite handily escaped being convicted and therefore removed from office. I think the major question I've put up here, sure it looks bad, but has President broken any laws, and if so, are they impeachable offenses, is likely to be whether the president solicited a bribe which could violate one of a number of federal statutes. Now, I've only got about a minute left, so I just want to close with a couple more thoughts. The way that impeachment is likely to be viewed in the United States is highly contingent on one's political perspective. We have a media environment in which Democrats predominantly consume news from one set of TV shows and websites and print electronic media. Republicans a quite different set. So there is basic disagreement not only on what policy should be, but on what the facts are. Contributing to this is rising economic inequality, which has been going on for the last 40 years in the United States. And it turns out that there's a pretty close correlation between these two things, political polarization and economic inequality, that I think we're still trying to get our arms around. This is a part of the reason why I believe that the kinds of allegations that President Trump makes about it being a crooked system, running against a rigged system, have some currency within a broad swath of the American public. A lot of people, actually, on both the right and the left in the United States, have the sense that the system is rigged. And I think it's our job as people like me who study elections and voting, people like the courts, people who are running elections, to help try to restore faith. And I'll close by saying the job of all of you as well here in Mexico. So I hope this has been at least somewhat informative, and I really appreciate you all taking time out of your busy schedules to listen to me today. Thank you very much.